Okay, for the record, this is the matter of CP1. Angelina L., docket number is CP 23013532. If I can ask everyone to identify themselves for the record, please. Starting on my right.
Matthew Lodice. Do you want my address?
Counsel?
Ellen Morgan, counsel for the mother Theodora Antar.
Theodora Antar, the petitioner.
Okay. We're here today for the limited purpose of addressing the petitioner's motion to recuse the judicial official, that being Judge Jessica Torres. Attorney Morgan, this is your client's petition. Proceed.
Yes, Your Honor. We're just going to present an argument today. We are not calling witnesses. I believe Your Honor is... let me withdraw that. Start over again. My client made request that Judge Torres recuse herself.
You can have a seat.
My client requests that Judge Torres recuse herself for a couple of reasons. Recuse herself from the pending termination of parental rights petition filed by my client, originally in probate court, and which was then transferred here. The sequence of events are as follows, Your Honor. My client filed a termination of parental rights petition in the Waterbury Regional Children's Court. It was then moved to the Waterbury Probate Court, which then moved it here. My client has filed a lawsuit against several officials, one of whom includes Judge Torres. While the canon of conduct does not require a judge to recuse him or herself merely because they are subject to a lawsuit, I believe in this case it would be appropriate for Judge Torres to do so under the discretionary clause of Rule 2.11 sub A sub 1.
Give me a second, Counsel.
Yes, Your Honor.
2.11. All right, for the record, you're referring to the Code of Judicial Conduct as Section 2.11 on disqualification. Is that correct?
That is correct, Your Honor.
And what subsection, please?
I am referring to subsection A, subsection 1. My client maintains that because of the pending lawsuit, Judge Torres would be implied to have bias towards her in her petition if Judge Torres were sitting on that petition adjudicating whether or not the petition should be granted. We believe that her participation in that pending petition would taint the proceedings. It would taint them for both parties, actually. For Mr. Lodice, if Judge Torres ruled in favor of the petitioner, Ms. Antar, I believe he would have grounds for appeal, or maybe an additional ground for appeal, because Judge Torres could be implied to have favored the petitioner as a result of being a subject of the lawsuit filed by the petitioner.
All right, Counsel, I'm going to ask some questions as we proceed here. Referring you to Practice Book Section 1-22. Do you have that with you?
I do, Your Honor.
All right, subsection B.
122B, yes, Your Honor.
Okay. Under subsection B, again, for the record, that states a judicial authority is not automatically disqualified from sitting on a proceeding merely because an attorney or party to the proceedings has filed a lawsuit against the judicial authority.
Yes, Your Honor.
So what is the purpose of that section of the practice book if the only argument here is that Judge Torres is a party in another lawsuit?
Your Honor, I don't disqualify that, obviously, don't disqualify that section of the practice book. I believe this falls under her discretionary authority to recuse herself. It's not mandatory. It's not an automatic, and I understand why it would not be an automatic. Someone could sue over a slip and fall or anything of that nature. However, the appearance of impropriety would lend itself to having Judge Torres recuse herself in order to make sure that these are clean proceedings.
All right, again, Counsel, I'm going to interrupt.
Yes,
I
Your Honor.
read through the file and the sections. All right. If the naming of Judge Torres in the other proceedings you think might impact the file, I asked the same question I asked before. Are you suggesting that in any proceeding where a judicial authority is named as a party in another lawsuit, they should recuse themselves?
I think it would depend upon the circumstances.
All right,
Your
so
Honor.
what are the particular circumstances here that you can point out to me that are relevant or probative of the motion to recuse?
Well, in this particular case, Judge Torres is not being sued just as a judge, an official. She's also being sued in her individual capacity, which would make her personally liable if the petitioner were successful in her lawsuit against Judge Torres and the other named defendants. So that, it could be a pecuniary interest, it could be a disciplinary interest. That interest on Judge Torres' part, in order to, I think, in order to keep these proceedings clean, would not require her. However, it would suggest to her that perhaps she should recuse herself in order to ensure that however the lawsuit comes out, however the termination comes out, there would be no additional appealable issues.
Okay, again, all right, am I correct
Yes, Your Honor.
that with respect to the other lawsuit,
Yes.
does that relate to anything Judge Torres did outside of her official capacity?
As I have read what has been made available to me, no, it has not.
All right, so if it was done within her official capacity, doesn't she have immunity from individual liability?
She may, depending upon the facts and circumstances that come out during that lawsuit.
But see, this is what I need to understand.
Yes.
Okay, if the issue, if what you're suggesting is not only is there a question of what she did as a judicial authority and named as a party, and something outside of that, if it's just within, I need to know what outside of anything she did in the other case. Let me ask it differently. What in particular can you point out to the court that she did in the other case that would remove the cloak of immunity?
One moment, Your Honor. My client is... my client maintains that... one moment. Just one moment, Your
Sure.
Honor. Your Honor, I believe that in making rulings upon the termination, that, rather, my client maintains that in making rulings upon the termination, petitions, and pleadings, that those were done outside of normal working hours. They were done outside of the courthouse. And
But how does that, again, how does that remove the cloak of immunity if it's not where you signed it or the time?
Yes,
It's
sir.
whether you're doing something outside of your judicial authority. So again, to try to get a handle on this, what was done allegedly outside of Judge Torres' judicial authority with respect to these motions that she denied, that would give her or create exposure for her in an individual capacity?
I do not have all of the particulars on what she's done outside. I do not have all the particulars of what she has done outside of her judicial authority, and I will freely admit that. However, I believe that in this particular case, given the pleadings that have been filed in court against Judge Torres and other parties, that in order for the termination to proceed, that it would be better for Judge Torres to recuse herself because of the appearance of impropriety.
Okay, but better is not the standard, is it?
I beg your pardon?
Better is not the standard.
No, better is not the standard. However, a reasonable person would, under the standard, take a look at somebody who is being sued. And while that same person is being sued, they are also adjudicating with the person who is suing them. A reasonable person would say, I think that a judge should step back. I think another judge should come.
I'm going to go back to my first question. If that were the case, what is the purpose of Practice Book Section 1-22B? Well, why would that be there if...
Because there may be situations where an official is being sued for reasons other than what they have done as a judge.
Okay, but let me ask another question, and I apologize, but...
No, you're...
All right, let's, for the sake of this argument, assume that there's an issue with Judge Torres's, her findings with respect to these particular motions that were filed.
Mm-hmm.
Okay, they were denied.
Yes.
Okay. Isn't that an appeal issue, not a recusal issue?
Why couldn't it be both?
Pardon?
Why couldn't it be both?
Well, I'm asking you, is it an appeal issue?
I don't think necessarily that those would be appealable issues because those were not necessarily final decisions. I think they were more interlocutory decisions. Because it does give the petitioner an opportunity to refile.
Have further argument, counsel, please.
Just one moment, my client is...
Please, take your time.
My client brings to the court's attention that she did, in fact, deny her fee waiver with prejudice, which would be a final decision. Now, that is not an appealable issue. You have a hearing on that. But requiring that extra step is both inconvenient for the court, it is inconvenient for the parties involved, and that is one reason why my client believes that Judge Torres should recuse herself.
Anything else?
My client would like permission to speak, but I don't know if Your Honor wants to hear her.
Well, again, counsel, you're here representing her.
Oh, she would like to speak to me. I'm sorry. I
Sure.
thought she wanted to speak to Your Honor.
Go, take your time.
Your Honor, my client would like me to bring to the court's attention that in Judge Torres' rulings, she indicated that the court did not have jurisdiction over the matter. That is clearly untrue. I mean, the matter was filed in probate, but probate had the authority to move it to juvenile court because juvenile court has the authority to hear these matters. And she believes that that is also an indication of bias upon Judge Torres' part.
Give me a moment, please.
Yes, Your Honor.
Hypothetically, if that decision legally was incorrect, how does that rise to the level of a disqualification? Does that mean that any judge who makes a decision that is wrong needs to recuse him or herself from a proceeding? Because I'm not opining on whether the decision was or was not correct. I'm asking it as a theoretical question on this motion. If you follow that argument to its logical conclusion, wouldn't you then be at the point where a judge makes a mistake legally? They need to recuse themselves. Is that where that would go logically?
If the judge continues along that line of reasoning without either correcting the mistake or allowing a party to bring that to the court's attention and then making the correct decision on it or the legally correct decision on it, I think that may rise to the level of bias towards that particular plaintiff, because the court is at that point not just making a mistake, but they are, to use a layman's term, is doubling down on it, which would then give rise to bias.
All right, let me inquire further. Do you have a copy of 2.11 that you can access? This is the Code of Judicial Conduct.
I have my practice book here.
Do you have it?
Yes.
Should be, okay. I'm going to ask you to look at 2.11, and it's A1 through again, in 2.11, Code of Judicial Conduct, A1 through A6.
Yes, Your Honor.
Under what section of that code would your argument be based?
Would I be arguing?
Sure. Is it just A1?
I would argue that, or rather my client would argue that it is A1, while A4, while it's not a public statement,
Well, this is juvenile court, so it's definitely not a public statement.
right, so proceedings here are confidential.
Right.
I would say A1, Your Honor, because the series of events and the series of actions taken by Judge Torres imply to my client that she has a bias towards her, and that bias is as a result of the lawsuit my client has filed against Judge Torres.
Okay. And any other comments for the court?
If Your Honor would my client further argues that the appearance of impropriety really does control this particular argument. Judge Torres made some wrong rulings. I believe she did make some wrong rulings. However, her continued insistence upon maintaining those wrong rulings without any correction leads also to the appearance of impropriety to my client and to the public, and for the proceedings in the underlying termination of parental rights. It is adamant, because we are talking termination of parental rights, where a state is moving in to sever the legal relationship between a parent and a child, that those proceedings must be as free from taint, free from the appearance of impropriety as possible.
Give me 1 second.
Yes, Your Honor.
So the TPR petition in this case is the petition is she must be the father, right?
It's labeled with tabs.
The petition is she must be the father.
PCT, yeah.
Am I reading that right?
Let me find the beginning.
Here it is.
This is the start of it.
This is the
This is the order transferring homes. No, this is the petition she filed. She said, yes. I'd like to test exactly.
Counsel, let me. You are referring to the TPR petition,
Yes, Your Honor.
and am I correct? Just wanted to check, and please correct me if I am wrong. That the TPR petition here is filed by your client
Yes,
against the biological father.
That is
It's
correct.
not a termination of parental rights with respect to her terminal rights. Is that correct?
that is correct, Your Honor.
So where is the prejudice to her on that argument, in that argument? But the TPR is against the other party,
Yes,
not her.
right.
So the state isn't coming in to seek to terminate her rights, yeah, are they?
Well, the state would be severing, if my client is successful, the state would be severing Mr. Lodice's rights.
All right, so, but it's your client's petition. I guess what I'm having difficulty understanding is if your client's petition were granted,
Yes.
and if that would happen and his rights were terminated, how does that prejudice her rights?
It would not prejudice her rights. However, it would give Mr. Lodice an additional ground to appeal, because if Judge Torres rules on that petition and then grants it in favor of my client, Mr. Torres clearly has, Mr. Lodice clearly has an additional ground for appeal if there are any other grounds, because Judge Torres is a subject of a lawsuit filed by my client. That, in and of itself, for Mr. Lodice, gives a rise of bias.
Okay, any other comments? Please?
At this time, no, Your Honor. However, may I have just a few minutes with my client?
Sure.
I believe she has something.
Sure. Okay, it is her petition.
No, it's not. It's not a victim. How is it a different issue? Because this is from the bias. It's shown. It doesn't matter. This was dumped here because that had been given to her. This is where the bias came from the beginning. His best friend. Look at this notion. She recused herself. Now they're saying, oh, she filed it with state didn't hire her. He had his friend assigned as the judge to try to benefit his situation. This is corruption from the beginning. Now you have Judge Torres showing this. And it says here that if somebody's not covering the issue, the judge's friend of the family, we didn't get the wrong this or the fact that you. I'm not talking about her, I'm talking about me. It says if a litigant is, and here's the timeline of events. It's also me. His comments about
Yeah.
this. Comments about what we're doing about us, the way the groups
I don't do this on record. We would send the
okay, but that's what I'm
decision
saying.
to
Can we
that
then bring
meeting.
her
Right.
up and say there's sort of respectful and she was, even, it is. Okay, we have, I feel like we have. This is kind of different. Because I feel like pages here, and I feel like there's a lot of evidence here that's not even being entertained. It's only focusing on one thing that's not the whole subject of, that took a lot of time to put together. I spent a lot of time.
Barbara, let's go off the record for a
Yes.
moment. Well, I'm sorry, let's go back on the record.
Yes, Your Honor. May we take a 5-minute recess? My client has some information that she wants me to bring to the court.
All right, we'll resume at 11:05.
Thank you, Your Honor. I appreciate Your Honor.
All rise. Court stands in recess.
Have a seat, please.
Court back.
Attorney Morgan, any other argument for the court, please?
Yes, Your Honor. My client has reminded me that she also believes that Judge Torres should be disqualified because of the notoriety of her lawsuit, which makes her a notorious plaintiff. And being a notorious plaintiff, my client represents that because Judge Torres is also sitting on her termination of parental rights petition, she, as a notorious plaintiff, would not be given a fair hearing because of her notoriety due to the lawsuit.
Wouldn't that apply to any judicial authority?
Not necessarily, because while somebody can be a notorious plaintiff, if that person is also suing the judge, that is hearing their matter is adjudicating another matter for that plaintiff, that poses a difficulty. It's one thing to be famous and be sued, but the judge is, not being sued by that plaintiff. The judge can hear that case as they would any other case. Where a judge is being sued and the plaintiff has become notorious or is notorious, it is better for the judicial system, for the appearance of impropriety, and for the swift administration of justice that the judge recuse him or herself to avoid all of the impropriety, appearance, etc.
Okay, Counsel, I have one other question. If you know, how many named defendants are there in the other suit?
403.
Thank you. All right, thank you.
Yes, Your Honor.
Mr. Lodice, do you have any argument you wish to present to the court at this time?
I would just like to say that, along with the judge hearing this case, pretty much any judge that's ever heard any one of our cases or Ms. Antar's cases is on that lawsuit, and I feel like any other future judges that get appointed to this case is just going to end up on that lawsuit too, and we're going to be back here having the same argument. It's just something like there's actually another recusal hearing going on in Milford right now that Ms. Antar filed against a judge that heard another case of ours in Milford. It's just like a pattern of behavior that just keeps happening with anyone who rules against Ms. Antar's favor. And I just feel like there's no need to keep doing this, and I wish we could just move forward as swiftly as possible. That's it.
Your Honor, if I may follow up with that.
Sure.
If there is a motion to recuse and that person is subject to this lawsuit, is one of the things, and my client has become notorious, considered a notorious plaintiff, then it is in everyone's benefit. It is in the party's benefit. It is in the system's benefit. It is in the public's benefit that a judge who is not associated with that lawsuit be assigned to oversee the termination of parental rights proceedings. That anyone who is subject to that law should recuse themselves, because the matter is now becoming public, it is becoming notorious, and in order for these parties to be able to resolve what needs to get resolved, someone who is not associated with that lawsuit needs to be the person to adjudicate that matter.
Okay. All right, I'm going to take the papers. I will notify my decision by the end of this week. I'm going to take the papers. Okay?
Thank you, Your Honor.
All right, thank you.
All rise. Court's in recess.
All right, so CP matter's done,
I'm calling Helen.
and then I'll go back, and as soon as the, let me know.
Yeah, I'll get Sharita.
Oh,
I'll sign
yes,
Sharita
good
down.
point. Yes, Your Honor, may we go back on the record? In one of the court memos,
All right, one second.
oh, I'm sorry.
All right, Barbara, let's go back on the record. Have a seat, sir.
Your Honor, in one of the court memos, there was discussion or notation regarding whether or not Ms. Antar would be provided counsel for her pending termination of parental rights, and that would be addressed today.
Is that correct?
I think that was. Yes, for the sole limited purpose of this hearing, and
Yep.
then.
I don't remember saying anything about future.
Yes, November 9th.
Court will address the issue on 12/15, so yes,
Okay.
because then it's 12/21 that was continued to hear, so yes. That's true, she's on for just this, and which was gonna be addressed when she gets counsel for.
Council, we'll have a ruling on that by the end of the week.
Thank you, Your Honor.
Same situation. All right, thank you. So the CP matter is adjourned.
All rise.